Assalamualaikum, Professor Dr. Mahmud Sanusi. How are you, Professor? I'm glad that I can have another session with you after the introductions regarding what's so-called Islamic banking recently. We're still focusing on the legal documentations and agreement, what so-called Islamic banking provided to the customer. The terms and conditions in the what so-called Islamic banking legal documentations, which it makes the customer losing their properties and assets to what so-called Islamic banking. And this will make their customers in dilemma, nightmares, and going to be bankrupt. And what so-called Islamic banking is doing is already 40 years. And they keep going on with the same agenda, planning, whatever they can do. So, Professor, we are really hopefully that you can address it more details, the core problems with this what so-called Islamic banking in your presentation, and how this what so-called Islamic banking draft the agreements, the terms and conditions, which will make the life of the customer, of the people is miserable. Thank you, Professor. Please do the presentation, Doctor.
Assalamu alaikum, brother and sister. I am very happy to meet you again. This is actually, as I promised you, is the second sessions for completing of the first session which we have before few months. And I am very sorry to delay because this session, because I thinking that instead I talk to you, I want to put it in writing. Then after my presentation now, the text will appear. Then you can read it many times, right, to understand. Actually, this session is about the legal documentation which what's so called Islamic banking drafted and give it to their customer for 40 years now. You understand? And if you read the text, and you will see that there are the two problem facing Islamic banking, and this will hinder the progress of Islamic banking, and also make people not satisfied with the practice of Islamic banking. The first one is the legal documentation, and the second one is the conflict in the legal system, and this one will be presented to you in the third session, not this session. But this session, I will concentrate on the legal documentations, which it is giving from a so-called Islamic banking to their customer. Okay, and this legal documentation, you will find out that all the legal documentation is more of deceiving and is not Sharia compliant at all. Even though you hear that they are Sharia compliant, but they are zero Sharia compliant. Actually, this legal documentation is mimicking conventional loan and credit-based conventional contract. You understand? So I hope you will enjoy reading, and it is quite long, and I put it in the writing, and someone will read it to you, so you can listen, and also you can read with the one who read it to you in black and white. Okay, and I hope you will enjoy it, and I need from you a feedback after you read it, right? And I will have one session in the end of the 3 or 4 session. Then I will try to answer every request from you. I hope you enjoy it, and don't forget to put your comment on it. And we are doing, you always remember, we are doing these things for the interests of our religions, also the interests of the welfare of the people, and it's enough and enough for 40 years that what's so-called Islamic banking exploiting the people, our people, you understand, and in fact make them bankrupt. Thank you very much, and Assalamu alaikum.
Conflict between Islamic fiqh, mu'amalat, commercial transactions law, and Sharia legitimate contractual terms and conditions rules, and the Islamic financial products and its banking legal documentation in the current Malaysian practice. Islamic banks in Malaysia proved a good case study concerning the conflict between Islamic fiqh, mu'amalat and Sharia legitimate rules and the current Malaysian Islamic financial agreements and its legal documentation. However, the discussion will be confined to two financial transaction agreements, namely, number 1, BBA or Bai Bithaman Ajil, and number 2, ITAP or Al-Ijarah Thumia Al-Bay. The salient legal agreements of BBA by Islamic banks in Malaysia. Example 1. BBA for asset acquisition. A bank purchases the asset concerned from the customers through the Property Purchase Agreement (PPA) with the condition that the latter must purchase the said asset again from the bank. The bank subsequently sells the asset to the customer via the Property Sale Agreement (PSA) at a pre-agreed price comprising the actual cost of the asset plus the bank's profit margin. The customer will settle payments by installments within a period so agreed. Example 2. BBA for refinancing. This is used mainly to obtain cash or liquidity without acquiring any assets. For instance, a customer sells his house to the bank on cash, say at $120,000, and the bank will immediately sell it back to the customer at $210,000 on deferred payment agreed between the parties. Such a sale constitutes a double sale or buyback agreement. BBA legal documentation or facility agreements in Malaysian Islamic banks involve the simultaneous execution of both Property Purchase Agreement (PPA) and Property Sale Agreement (PSA). Number 1. Property Purchase Agreement (PPA). The provision states, the agreement between the customer and the bank, wherein the bank purchases the property from the customer for the purpose of immediately selling the same to the customer on deferred terms under the Sharia principles of BBA. Here, the customer sells his right over the property to the bank with immediate buying it back. There are express provisions in PPA to state that the ownership and all rights of the property shall pass to the bank upon the execution of this agreement. Number 2. Property Sale Agreement (PSA). This agreement reflects the act of reselling the same to the customer upon deferred payment, which includes bank's profit margin. The agreement also states the ownership of land rights of the property shall pass to the customer upon the execution of this agreement. However, in practice, under the BBA banking procedure, the above transfer of ownership is not done in the real sense. In example, by filling the Memorandum of Transfer, or MOT, and by using relevant forms, which subsequently has to be presented in the Land Office or High Court, whichever applicable. Instead, it is only done on paper or credit documents. As such, the Buying or Purchase Act of the bank is evidence from PPA, appears to be merely a document solely to give the impression that the bank has purchased the property from the customer for the purpose of immediate reselling the property to the same on deferred payment. In pursuance thereof, the bank agrees to sell and the customer agrees to buy, based on the terms and conditions agreed in the facility agreements. Thus, first, there is no physical or actual trade taken place. The bank merely trade goods on paper or credit document against a predetermined rate of profit margin without bearing any risks and liabilities. And second, the contractual relations between the bank and the customer have to be concluded on mutual exchange consent, mutual goodwill, and mutual acceptance between the contracting parties, where one party does not exploit the other party. This is the basis on which contractual relationship must be concluded, and wherever there is exploitation, it must be eradicated. Furthermore, the bank as a seller is not liable for any defect affecting the house or property sold. The bank, not being the developer of the property, shall not be liable for any claims in respect of any defects, shrinkage, or faults affecting the property which are due to defective workmanship or materials, or any other cases whatsoever of the property are not having been constructed in accordance with the specifications and plans approved by the appropriate authority. However, the customer cannot make any claims against the vendor or proprietor arising out of the sales and purchase agreement SPA. It means that the bank as a seller has waived his liability in relation to the defects and faults existed in the house. Such term or clause must be considered as a null and void due to the risky nature that makes it similar to gambling, risk-taking, and excessive gharar, excessive uncertainty, which render the purchase agreement SPA totally null and void. Currently, Islamic banking legal documents face several challenges. It should be acknowledged that the documents adopted by Islamic banks cannot meet all the Sharia compliance contracts and Islamic fiqh mu'amalat commercial transaction law legal requirements. Replication from the interest and credit-based conventional banking documents is a disease facing current Islamic banking legal documents. Furthermore, deliberately forgetting about Islamic fiqh mu'amalat principles and rules is also a huge omission practically facing current Islamic banking today. Islamic banking legal documents would be in a standard from which entails details of terms and conditions. The terms and conditions are binding, fixed, which are inevitable part of the agreement consequences and non-negotiable. Usually, without negotiating the agreement terms and conditions, ignoring the Sharia required is that the contractual relations have to be concluded on mutual exchange consent, mutual goodwill, and mutual acceptance between the contracting parties, where one party does not exploit the other party. This is the basis on which contractual relationship must be concluded, and wherever there is exploitation, it must be eradicated. The signature on the banking document is insufficient to prove that the customer understands his rights and obligation which he is entering to. The lack of true knowledge on banking documents is the main reason that the Islamic banking financial facilities most of the times are generalized as loans or credit-based contract in the court judgment and judicial decision in contractual disputes. These are the principles on which the Contract Act and other laws dealing with contract have to be judged. It is also evident that there is no physical or actual trade taken place. The bank merely trade goods and assets on paper or credit documents against a predetermined rate of profit margin, usually benchmarked against LIBOR or OPR or a national alternative from the conventional sector without bearing any risks and liabilities. Number 2. ITAB or Al-Jiyarah Thumma Al-Bay. In Malaysian Islamic banking, Al-Jiyarah Thumma Al-Bay can be safely defined as a contract of leasing with a condition that the customer must purchase the asset on maturity date. In example, the end of the lease period. If the customer wishes to discontinue the Al-Jarrah contract, he will be offered to buy the asset at a price equivalent to the difference between the total and the amount he has already paid as rent. ITAB has to operate within the Malaysian Hire Purchase Act 1967. However, it must be noted that the Hire Purchase Act 1967 remains a law governing interest-based loans granted by a bank to the borrower. By this way, ITAB in Malaysia assumes the identical legal structure to the conventional hire purchase contract. The bank, as the lessor, does not hold legal ownership in its true sense. It holds the right to sell or dispose of the asset if the lessee found on payment that does not fulfill its obligation as the true owner of the asset and bearing all the risks and associated with the ownership. This is because the bank tends to escape all risks and liabilities attached to the ownership. The bank seems to operate on the same basis as the interest and interest-based loans conventional banks, in that it does not fulfill the responsibility of the owner of the property to protect the property. By taking out an insurance policy and paying out all duties and taxes, as well as asset maintenance. These liabilities and responsibilities are all borne by the lessee. Furthermore, the cash flows involved in ITAB financial lease are cleverly structured to look very much like an interest-based loan secured by the collateral. The asset's rental should be based on the rental values of the assets. Therefore, the bank would merely act as financiers, no more, no less. The Ijarah legal documentation in Malaysia involves contemporaneous execution of two agreements, namely, number 1, Asset Purchase Agreement, APA, which signifies the purchase of an asset from the customer in order to obtain ownership over the property before the bank can lease out the same to the customer. Number 2, Asset Lease Agreement, ALA, which it signifies an act of leasing undertaken by the bank immediately both after the bank has obtained the ownership over the leased property and the execution of APA agreement. Analysis based on fiqh rules. The closer examination of the above-mentioned Islamic financial transaction and its legal documentations practiced by Islamic banks would seem to contradict the principles laid down in the Quran and Sunnah in relation to fiqh mu'amalat and its principle of al-qawaid al-fiqhiyah, all of which have earned unanimous consensus and application. Thus, these financial instruments contain elements of legal device in its mechanism and modus operandi, which deviates from the true objections of the Sharia simply because it is adopting the transactions and agreements mechanism of interest-based banks by practicing the method of patching or talfiq. After altering the labels of these transactions and agreements and using Arabic terms equivalents to the English terms. These practices in Islamic banking are creating a marked degree of confusion among the layperson in understanding the wide and real difference between halal and haram acts in Islam. Simultaneously, other objections have been raised against the Islamic financial instruments as they are currently practiced. It is submitted that they contravene the principles governing fiqh mu'amalat rules. The objections are as follows. Number 1. That the study of BBA and ITAB mechanism and legal documentation currently practiced by the Islamic Bank constitutes by al-inah or organized tawarruk, banking tawarruk, is not permissible under Islamic law, which is considered as a legal device or hilah and haram in fiqh mu'amalat. Al-inah or organized tawarruk are one of the set of legal stratagems whose prime function is to attain illegal ends through legal means. Inah or organized tawarruk are defined as the use of the contract of sale to render possible the loan of money for interest. Thus, such contracts are invalid since unjustified enrichment fadmal bila iwad violates the Islamic principles of justice and equity. Number 2. That a BBA transaction constitutes two sales in one transaction. This situation has led to much confusion in the Islamic nominate contract. In example, as to which set of contract rules to be followed. Such practice is considered forbidden and violates the rules of Islamic law transactions. That BBA transaction constitutes a sale with a condition, which is contrary to the legal nature and purpose of the sale contract. By making the promise to purchase binding, the bank renders the transaction invalid. It would be considered as a null and void and unlawful. BBA legal documents should be free from compulsion and duress, fraud or misrepresentation from either party. The contract should not be about anything prohibited by the Quran and no doubt by the Sunnah. This is to prevent making a contract of sale into two transactions or to attach an extra invalid condition with a sale contract. That BBA legal documentation involves a sale prior to taking complete ownership or possession by the bank, while it is a requirement of a valid sale in Islamic law, that the seller or the bank may not sell the goods purchased until they are in his real possession, and transfer of ownership is complete ownership. The role of the Islamic Bank is minimal in BBA agreement as practiced nowadays, and is just limited to the act of delivering the various checks and signing the what's so-called legal documents. Such a deal can no longer be a BBA agreement, but rather a loan with interest, or qad bi al-fa'idah. This is because in such agreement, the Islamic bank is just lending money to the customer for a determined marked-up based financing, which is usually benchmarked against LIBOR or OPR or a national alternative from the conventional sector without bearing any risks and liabilities, with the addition of a few more documents to be filled in. Number 1. that legal documentations of BBA and ITAB shows that Islamic banks is not held liable for any defect in the goods or manufactured item sold by the bank to the customer. Such a practice is not in tune with Islamic law of contract and its legal maxims. The rule is that any condition or clause to waive the responsibility of the seller from any defect in the commodity sold must be regarded as absolutely void. Thus, any clause by the Islamic banks to exclude their liability from any defect in the manufactured item shall be considered null and void. The logic of this rule is clear when nowadays BBA and ITAB is concluded with assets and properties involving high price and technology, where any defect will lead to a huge financial loss. Based on the foregoing and ultimately having examined these financial instruments and its legal documentations currently practiced in Islamic banks, it is apparent that from the standpoint of the fiqh mu'amalat rules, such as financial instruments are deemed unlawful and null and void according to the Sharia rulings because, generally, it is not adhering to the principles of the Islamic legal maxims which have been developed by Muslim jurists to provide an accurate and consistent basis for ruling of the commercial transactions. Undoubtedly, it conflicts with the Islamic general legal maxims and maqasid al-Sharia. In addition, one cannot find any sound argument for its genuine validity. This salient point can be illustrated via a number of equitable legal maxims or qawaid fiqhiyah as quoted in the ensuing. The legal maxims that says A. Any act which does not achieve what is intended for is considered void ab initio. B. In contract, effects are given to meaning and intention and not to words and forms. C. Liability is an obligation accompanying gain. And D. Everything which leads to a forbidden thing is forbidden. These legal maxims have formulated legal rules which have established a criterion for the general character and attributes of fiqh mu'amalat, and to identify the unacceptable practices that have recently surfaced in the practices of Islamic banks. The legal maxims in question imply that contracting is not just a matter for parties to pursue their self-interest. Rather, contracts are subject to the religious and moral constraints in molding economic activities. Thus, anyone who seeks to obtain from the rules of Sharia something which is contrary to its purpose has verily violated the Sharia, and as a result, his actions are interpreted as being null and void. Furthermore, any form of business dealings without bearing any risks and liability is forbidden. Therefore, the failure to recognize the general principles of Islamic law and its objectives, which is contained in the Quran and Sunnah, would render one's practices void and unacceptable by Allah subhanahu wa ta'ala, and the worst scenario is that one might be construing what is forbidden by Allah subhanahu wa ta'ala without realizing it. In this context, researching issues related to Islamic banks and finance should be expedited in the context of various legal maxims so as to avoid future legal disputes and misunderstanding about the true nature of Islamic banking and financial instruments, which rest solely on the basis of justice and equity. Notably, the above-mentioned legal maxims established the principle of justice in Islamic fiqh mu'amalat, which balanced the rights and obligations of the contracting parties. Any imbalance between each party can be easily seen as eating others' money for nothing. In Islamic law too, the subject matter of the contract is one of the essential ingredients of the contract. Its absence makes the contract void. Imam Nawawi, in the Minhaj al-Talibin, states 5 conditions necessary for the validity of sale of anything. The first, it must be a legally pure substance, not, for example, a dog or wine. The second, it must be of some use and consequently of some value, for example, not vermin. The third, the vendor must be able to deliver it to the purchaser. The fourth condition, the vendor must be the real owner. And the final condition, the thing must be distinctly known to the 2 contracting parties. Al-Nawawi also states that for the validity of the contract of sale or exchange, the law requires mutual consent. Thus, it is of the essence of the contract that both parties should understand the obligations created by it in the same sense. If there is no consensus of minds on that point, the very foundation of the contract disappears, and therefore there cannot be a breach of a non-existent contract when parties enter into a contract under a mutual mistake or misapprehension as to a matter of fact essential to the agreement. Section 13 of the Contract Act brings out the same point when it says, 2 or more persons are said to consent when they agree upon the same thing in the same sense. It is also observed that an Islamic bank that practices al-bay bithaman ajil or al-ijara thumia al-bay seems to only champion its rights without conferring duties of equivalent values to the customer or the buying party. Apparently, it has transferred relatively all the risks and liabilities to the customer, thereby leaving it, in example, the bank with practically no risk to bear while securing profits, which is fully guaranteed by way of executing. Number 1, BBA or Bay Bithaman Ajil, and number 2, ITAB or Al-Ijara Thumia Al-Bay. A closer examination of the above-mentioned Islamic financial agreements and its legal documentation practiced by Islamic banks in Malaysia has unveiled the disturbing feature of BBA and ITAB agreements, in which would seem to contradict the principles laid down in Islamic fiqh Mu'amalat and Shariah legitimate rules. Islamic banks in Malaysia have passed greater responsibilities, thereby transferring responsibility and liability onto the customer as follows. Number 1. For securing the payment of sale price, the customer shall execute a registrable charge in favor of the bank. Charge document or deed of assignment. This is an agreement made between the bank and the customer, whereby the latter agrees to assign all his rights and interest over the property to the former as security for the financing granted. Charge documents will be used when the issue document of title, IDT, has been issued, while deed of assignment is used when the IDT is yet to be issued. Such blinding clause in the bank agreement will be a violation of Islamic fiqh mu'amalat, commercial transaction law, legal requirements, and Sharia law when the bank forcefully impose a condition that transfer relatively all the risks and liabilities to the customer, thereby leaving the bank with practically no risk and liabilities to bear, while securing a fixed markup profits. Number 2, the customer shall take takaful mortgage plan as well as fire takaful for the amount accepted by the bank. Number 3, the customer shall indemnify the bank against all losses that may be brought at any time by the vendor or proprietor or any party or parties. Number 4, the customer to pay all quit rent rates, taxes, assessments, and other charges imposed or to be imposed by the government or other competent authorities, and other charges or levies in respect of the property, whether before or after the date of the execution of the agreement. And number 5, all stamp duties, taxes, fares, fees, expenses, and other charges in connection with PPA, as well as litigation costs and solicitor costs, etc., shall be borne entirely by the customer. The question that arises is whether Islamic law recognizes the above mentioned binding clause in the bank agreement and forcefully the customer to execute a registrable charge documents in favor of the bank.